long as you can speak into it. Well, press the button. There you go. Excellent. Go ahead and raise your right hand. Do you swear or affirm the testimony you're about to provide is true and accurate?
I do.
Ms. Ryan?
Good afternoon, Mr. Holt.
Good afternoon.
Are you the same Stephen Holt who filed direct testimony on July 24th, 2023 in this docket?
I am.
And if I asked you the same questions today, would you give approximately the same answers?
I would.
Do you have any corrections to make to that testimony?
No, I do not.
Your Honor, I would move to admit Mr. Holt's testimony.
Are there objections? No objection. Sorry, was that no objections? That was very quick. No objection. Thank you. Mr. Whippel? Good afternoon, Representative Holt.
Good afternoon.
I'm going to admit that real quick. Seeing no objections, the board will admit the evidence, give it the way due. Go ahead, Mr. Whippel.
Representative Holt, during the cross-examination of Summit's Chief Operating Officer, James Powell, I was inquiring with him about the denial of the permit in North Dakota, and it's his testimony that considerations with regard to Bismarck caused some of that determination in North Dakota. You represent the city of Erling, do you not?
I do.
Do you agree with Mr. Powell that Erling isn't entitled to the same consideration as Bismarck?
I do not. There's, as I said in my testimony, my objection is not to the pipeline being built. My objection is to the use of eminent domain to seize the property of my constituents to build something that I think is a private economic development project and does not fit the requirements for the use of eminent domain. And my constituents and my property owners in Erling and across my district and across the state of Iowa deserve every consideration when we're talking about such a fundamental constitutional question as the seizing of their land.
I'd also like to ask you the same question I asked Representative Eisenhardt a moment ago, but how should the board consider the federal tax credit subsidies for these projects? Should it be considered a cost or a benefit in the weighing of this permit?
You know, my objection to this, again, I would say, has never been about the economic development aspect. I love it when people make money. I'm a capitalist. I love capitalism. My objection is to the use of eminent domain. So I think in that regard, it's a terrible cost that my constituents and the folks in Iowa are paying when their land is going to be seized for this economic development project that, again, does not fit the Iowa constitutional requirement or the statutory requirements we have in Iowa Code for the use of eminent domain.
So subsequent to the filing of your direct testimony, Summit filed rebuttal testimony that included a renewable fuels study and a updated economic impact analysis from Ernst & Young. Has either of those, does either of those reports change your opinion of the benefits of this project?
No, sir. As I've said before, I'm all for the pipeline being built. I don't understand why it cannot be built through voluntary easements, because it is, in my judgment, a private economic development project that does not fit the Iowa constitutional requirement of public use, such as a propane, a gas pipeline or an oil pipeline that provides products that are essential to humanity. That is what public use means. Further in Iowa Code, in Section 479B, it gives very clear direction and limited authority that the legislature has given to the Iowa Utilities Board when it says the proposed services will promote the public convenience and necessity. And this pipeline does not meet the public use requirement, nor does it meet the public convenience and necessity requirement that are stipulated in the narrow authority that we give to the Iowa Utilities Board. So the economic benefits do not change the fact that I do not believe that the request for eminent domain is constitutional or statutorily allowed in this case.
Thank you. That's all I have, Your Honor.
Mr. Taylor?
Thank you. Representative Holt, to pick up on that last comment, of public convenience and necessity. You said that that is a narrow concept. What do you mean by that, and how can you describe how narrow it is?
Yeah, objection, Your Honor. State your objection. Calls for a legal conclusion of the public convenience and necessity.
Sorry, Mr. Leonard, you're speaking just a little too fast. I just can't quite hear you.
Okay. It calls for a legal conclusion as to the meaning of public convenience and necessity in the statute.
Mr. Taylor?
He's the one that brought it up, and he put it in his testimony, and I'm just asking him to clarify his testimony, what he meant by public convenience and necessity being a narrow concept.
Witness may answer if he knows.
I would say, as a policymaker, chair of Judiciary Committee, I have the responsibility every day that I serve the people of Iowa and my constituents to make decisions on the constitutional meanings and on the meanings of laws that we pass. I have consulted attorneys on both sides of the aisle, both sides of the political spectrum, and I think we've all believed for a long time that the definition of public use, I think we understood that for a long time until perhaps the Kelo versus New London decision, which the Iowa Supreme Court has made clear that they sided with the dissent in that case. Public use is different from public benefit. As I said before, public use is those things I think that are essential for humanity. Public use. Pipelines that move oil and natural gas are different from a pipeline that's going to ship CO2 and bury it in the ground in another state. I don't see how any amount of mental gymnastics can conclude that fits the public use definition of the Iowa Constitution.
Representative Holt, we need you to slow down just a little bit. Okay. We need to make sure
that
the court reporter catches all of this for the record so that we can make the decision.
I apologize, sir. Okay, so I'll slow down. You can see that I care about this issue a lot, so I'll slow down and try again. I don't see how anyone, when you look at the public use requirement in the Iowa Constitution, and we know, as I talked about, propane or oil or highways, those things that are essential for humanity, is what was put in the United States Constitution and the Iowa Constitution when we talk about public use. And as I said, I don't think shipping CO2 in a pipe and burying it in the ground in another state in any way, shape, form, or fashion fits the definition or fits the requirement for public use. When it comes to the convenience and necessity, the Iowa legislature has gone a step further in granting the authority to the Iowa Utilities Board in saying that in addition to public use, it must also fit all of the above: convenience, necessity, public use in the Constitution, and then convenience and necessity. And not convenience and necessity for some carbon solutions, but convenience and necessity in public use for the citizens of Iowa. And again, in no way, shape, form, or fashion do I believe that this project fits that high standard for which the government can come in and seize the private property of landowners in Iowa.
Summit has made the claim that its project will support the ethanol industry in Iowa. How do you see that in terms of public convenience and necessity?
Again, I think that that is great if that turns out to be the case. I will say again, I do not believe that fits the standard of public convenience and necessity. And if we're going to go that far and draw that conclusion, then I would say that we have no private property rights protections in the state of Iowa if we go there. Because you can say that about building a high-rise hotel. Let's take the private property of citizens and let's build a high-rise hotel, because the tax money we get from that, we can build child care centers or whatever. So I think if you go down that road, just as Justice O'Connor said in her dissent in Kelo versus New London, you have destroyed the protections in the Takings Clause of the Fifth Amendment, and you will have destroyed the protections in the Iowa Constitution for public use if you go down that road.
On page 10 of your testimony, my notes reflect at least that you asked the board here to not rush headlong into approving a permit. I had page 10 in my notes. Do you remember asking the board not to rush headlong into approving the permit?
Yes, sir, I do.
And why did you put that in your testimony?
Because especially now with what is going on in several other states where, they put a stop to or initially disapproved some of the permitting, this is a fundamental constitutional question here. For my constituents and for folks all across Iowa, we're talking about the taking of their land, which I will go back to what George Washington said, which we all should remember these words: freedom and property rights are inseparable. You can't have one without the other. Freedom and property rights are inseparable. You can't have one without the other. Why? We don't need to rush this. There's no reason whatsoever to rush this. I think we need to get all the facts on the table. We need to be respectful of the landowners whose fundamental rights are at stake here. And particularly when you look at what has happened in over the course of the last few weeks with some of the things that have gone on in other states, I don't understand why we don't, and I hope that we will, very carefully take our time in considering what is at stake here for the property owners when we're talking about such a fundamental constitutional right as private property, or the seizing of it.
Or do you think this project, or this process has been rushed?
I have heard from a number of landowners and constituents in my district who are very concerned about the modified schedule. And I've also heard from the other side on why they were doing what they were doing. I will give respect to that as well, but I don't understand why we need to have a deadline, because at this point in time, the deadline is all about what is in the best interest of the Summit. It is certainly not about what is in the best interest of the landowners whose fundamental constitutional rights are at stake.
Okay. Thank you. That's all the questions I have.
Thank you, Mr. Jorde. We have you next, but Representative Holt, I understand your passion. We need you to slow down and lean back just a little bit.
Okay.
It's difficult to hear you.
All right, I'm sorry.
You're all right.
I'll lean back.
Mr. Jorde?
Yes, thank you. Just for the record, what area of the state do you cover when you mention your constituents?
My current district is District 12, which I represent all of Crawford County, about half of Shelby County, and all of Ida County.
Okay.
Over in western Iowa.
Very good. And so you have constituents in those counties that are potentially affected by this project?
Absolutely, most particularly in Shelby County.
Now, you had mentioned the phrase about, in your mind, it's the question of if the proposed services will promote public convenience and necessity. In your mind, proposed services, is that Summit's offering to ethanol plants to transport carbon dioxide? Is that the service you believe that's at issue?
I don't know of any proposed services in this proposal that promote public convenience and necessity. I don't see them.
Okay, so if their proposal is to the act of transporting CO2 molecules somewhere in North Dakota for permanent storage, that's the service that you don't believe fits the public convenience and necessity standard?
Based upon how we've always understood public use, and I think we all know how important that is, and that was supposed to be a very, very high bar before land could be seized. So public use, again, as I said before, meaning natural gas pipelines, oil pipelines, highways, those things that are essential for human survival and that we understand to be public use. Again, if we stretch that definition in a way that is becoming more like public benefit, which is what I would suggest is happening here, then we are destroying the private property right protections private property rights protections that we have in the Constitution and that we have statutorily in Iowa Code, in my judgment.
But what do you say to the argument that, if the transportation services to transport CO2 are there, then maybe those ethanol plants can make a little more money. Maybe they'll pay a little more for corn for a period of time, and maybe the local farmers will make a little more money. Are you saying that's too tangential and speculative?
I think that's outstanding, and I hope that happens for our corn growers. but that does not rise to the level of public use, and it does not rise to the level, in my judgment, that meets the requirements in the Constitution and in our statute for which eminent domain can be used. So as I've said several times, let the pipelines be built using volunteer easements, but not using the heavy hand of government to take the land of others for what is a private economic development project that does not, in my judgment, fit the constitutional or statutory requirements.
So, in summary, sir, are you saying that as long as the people, the landowners, can choose whether or not they want to host a hazardous pipeline, and we removed eminent domain, then that would kind of remove your disagreement or opposition to the way the project is currently proposed?
I think that's correct. My issue is the use of eminent domain.
All right. And so if for whatever reason the project was approved, it would be your position that, if you're going to approve the project, fine, but don't approve the Exhibit H request for eminent domain for each of the parcels, right?
And I would also add that, I'm not here to argue the science back and forth about the sequestration of CO2. I have my own opinions about those things, but that's not why I'm here today, and that's not what my testimony was about. My testimony was about the use of eminent domain.
Okay, so okay, that's fine. I think I got it, sir. Appreciate it. Thank you.
Representative Eisenhart, and a quick reminder, we are in a hearing, gentlemen, not the House floor, so we have to play by our rules today. Go ahead.
Thank you, Mr. Chair. I remember the rules from long ago. One question. This project proposes to reduce atmospheric carbon dioxide to fight climate change, prevent carbon dioxide from getting into the atmosphere. Would you consider that a public necessity?
If you buy into that argument, then perhaps. Again, I think that is far from proven. And I'm talking about public convenience and necessity for the citizens of Iowa as the way public convenience, necessity, and public use has been understood. And I do not think it rises. I don't think it meets that. No, sir.
Thank you.
Thank you. Are there questions from the board?
Just one quick question here. Good to see you, Representative Holt.
Yes, sir. Good to see you.
So, and I believe you were first elected what year?
2015 is when I took office.
Right, and you overlap by at least a term. So,
right.
Since Dakota Access was built in 2016, has the Iowa legislature made any changes to 479B?
There had been some changes made when you and I were together, I think, when there were some changes made by Representative Kaufman regarding the use of eminent domain. We were in some of those, I think, together. I think you were still in the House at that time.
All right. That's all I had. Thank you.
Thank you.
Thank you. Representative Eisenhart, your placard's still up. Ms. Ryan for redirect.
Just one quick follow-up question after Mr. Burns' question. With respect to legislation that would change 479B, has the House of Representatives taken any action that could change it?
Well, we did. I floor managed and sponsored a bill that would have created some additional protections for landowners. That would have created a 90% threshold before eminent domain could be requested. It also had some additional land protections for landowners related to damage to crop yields and all those sorts of things. That passed with strong bipartisan support in the House, went over to the Senate, where action was not taken. And I think that would have fit well into what we currently have in Iowa Code. I don't think had that passed and become law, it would have changed the requirements that are still there for public use in the Constitution and for convenience and necessity that are currently in code. But yes, we did.
Thank you. That's all my questions.
Thank you. Thank you. We appreciate it.
Thank you all.